Welcome to Trust GBS. In each episode, we'll get together with other professionals and have fun talking about trust and estate matters. You can find this show on all the major platforms, including YouTube, LinkedIn, Facebook, Apple Podcasts, Spotify, and on our website, lawgbs.com. Now here are the hosts of Trust GBS, Lori Bolander and Lauren Gallagher.
Hello, I'm Lori Bolander.
I'm Lauren Gallagher.
Welcome to Simplifying the Complicated, where we talk about trust and estates related issues. Today we have our second-time guest, Lawrence Mudgett, here to talk about landlord-tenant issues. He was on season 1 of our podcast, and this comes up so often in our world that we thought it would be great to have him back on. Plus, we enjoy chatting with him. So he deals with landlord, tenant, and real estate law. You want to tell us anything else about your practice, Lawrence?
Sure. And thank you for having me on again. I didn't know I was your first repeat, and I'm honored to be back. I've been an attorney now, it's hard to believe, 19 years, and primarily landlord-tenant. That's the bread and butter, and I'm sure we'll talk a lot about that. I also do real property litigation work. So when civil lawsuits get filed, usually somewhat tangential to an eviction lawsuit, but not necessarily. Sometimes contractual things come up. And then I also do some bankruptcy work, mostly creditor side. I kind of came up in that world a long time ago, but I still know my way around. So when these bankruptcy issues come up, I can handle those in-house as well.
Yeah. That does tie into landlord-tenant sometimes, huh? If they are looking to not be evicted.
Yeah, I just last week was in bankruptcy court on a motion for relief from stay. It was a rent case where somebody just filed to try to stop the eviction proceeding. But I actually get into some more complicated stuff like post-foreclosure issues with bankruptcy and adversarials, so it can be more than just your run-of-the-mill relief from stay. But yeah, I certainly don't see them as much as we used to see them back in 2009, 2010, but they still come up.
Yeah.
Why is
interesting?
The Great Recession. My personal opinion, filings are way down in the district because usually it takes a foreclosure, an imminent eviction, something big like that to get someone who's on the fence to actually file. I did a lot of consumer side debtor work many years ago, and I would see people all the time like they probably should have filed, but they would fight and do everything they could to try not to. And then when they were all out of options, they pull the card. So I just don't think most people are at that stage like we were back then when there were all those foreclosures going on.
Now, is it because we're kind of going off a different path here, but is it because there's more consumer protections that give them more time or more options without having to go that route? Does that have anything to do with it?
In my opinion, I think it's part of it. So there are more protections, more things you can do on the tenant side, more issues you can raise to delay things before pulling a bankruptcy card. But I think really it has more to do with the volume of foreclosures. That there just aren't as many defaults now as there were then.
Interesting.
You got a lot of landlord-tenant issues to deal with, though, right?
Yeah,
indeed.
World? Yeah. So, do tenants still hold all the cards?
Yeah, it's a mixed bag. And that's that kind of question or a variation on it is the one I get more than any, right? Like, oh, it's California, so everything's for the tenants, right? And what I always tell people is, if you look at any of these tenant protections, even the recently passed locals like Lemon Grove just did a terrible one. City of San Diego, Chula Vista, Imperial Beach all have these local ones that are more protective than state law. If you go through them line by line, there's some stuff that goes too far, but most of it you'd go, it's reasonable. You got to have just cause to evict somebody, and here's what we consider to be just cause. And if it's not their fault, then they need a little rental assistance on the way out the door. I mean, you could argue it, but it's not just so far in left field. I think where things, in my experience, break down is the application of these rules in court, right?
Mhm.
So there's one eviction department for the entire county. So from Otay to Fallbrook out to Watay, everywhere in between, unless you file unlimited, it's all going to be running through one department. So that's a lot of cases. And, it doesn't take much for things to start slowing down. And then that's where I think that if you're a landlord and, hey, I've won my case, right? You went to trial, we got the judgment, but it's been a couple of months here. And I should clarify that the new judge is doing a fantastic job. And we've definitely seen a pickup in times that it takes to get signatures on things.
That's good.
Great. Yeah.
When it's bad, like there have been periods it's 3 months, right? And then you're waiting for the lockout after that. And of course, you're not being paid any rent during that time. So I think for your owner, your average client's gonna feel like they lost even though they won, right? Because it takes so long in the execution of these things. And then also too, you can see there's a lot of gray area, particularly the local protections, I think are rather ambiguously drafted. So, you can spend several $1,000s in a case just to get out of the demur stage over some statutory interpretation argument from tenant counsel. So things like that will slow it down and add a lot of expense. But I wouldn't go so far as to say like that the tenants hold all the cards. I would say it can feel like that. It can feel like that because of the way the process plays out.
Good.
Yeah, well, and of course we encounter this usually in our practice. I mean, I have some, estate planning clients that are alive that are landlords that sometimes I send to you to deal with tenant issues, but a lot of times it's, mom or dad have died and either they had a rental property with an actual tenant in it, or we have some sort of, family member or friend or acquaintance that mom or dad have allowed to live in the property.
Mhm.
And so, kind of looking at those from two different sides of it. So if you've got a rental property with an existing lease, explain to us kind of how that works. If, I'm the trustee and I'm now stepping in and I've got this tenant with a lease, does the lease still hold up? What are our steps?
Sure. So the lease would survive the death, right? The successor trustee or whoever the heir is would just be the new owner of the property. I think where a lot of problems come up, especially in kind of the mom and pop informal ones, or hey, we're letting Junior live at the place and he does the gardening or something. There's no writings, right? There is no written lease. There's no ledger. Everything's just been a handshake, a wink and a nod. And then that can be more difficult to fit into like the just cause construct and come up with the reasons for the eviction. Because a lot of times in those cases, I've seen it more times than I can count, right? You have somebody who's paying like grossly under market rent for a property. But there's like 20 years of deferred maintenance. And then mom and dad or whoever the deceased, they're happy, they're getting their $1,500 a month and it's paid for, so they don't really care. And then Junior gets it and it's like, geez, we could put 20, 30 grand in this place and take 3,000 a month, right? So getting a tenant out like that, especially where there haven't been very good records, but whatever the rent is they've been paying, can be a lot more difficult than you would think, right? Because you're limited
with that just cause before, because remind me, because it's if you're taking it off the rental market, that can be just cause.
Sure. And that's probably the most used one. It's your rights under the Ellis Act. So in your hypo, right, the successor trustee has the right to go out of business as a landlord, and I'm not going to rent this thing to anybody anymore. We're going to list it. We're going to sell it. I see it all the time. That's the most used reason, but it's also often the most contested, because people will say, no, you're just trying to get rid of me so you can rent it for more. This reason is a pretext for an eviction. So, walking that line in court, and, the judge is the backstop, right? You got to prove to them, or the jury, that this isn't in retaliation or for any other reason. You truly are going to take it off the market to sell.
Have you ever seen that come back where, because I can see, and I've had clients say to me, well, we'll just say we're taking it off the market and then we'll fix it up and then we'll re-rent it, which is exactly what they're not supposed to do under that, theory, right? Have you ever seen anybody come back and say, oh, they actually did re-rent it? Have you ever seen that happen?
I have not. I get asked that one a lot. I've never seen it where someone, comes back and says, hey, they didn't sell it.
Yeah.
I'd imagine it's happened and it's out there, but I haven't personally dealt with it.
Yeah. And then what are the notice requirements? So let's say you inherit the property, you've got, either a tenant with a month-to-month sort of lease or no lease. How much notice do you have to give them? Does that vary from Lemon Grove to Chula Vista or is that pretty standard?
It varies in what goes on the notice. It's basically going to be 60 days. It could be 90 if there's Section 8 or something. It also could be 120 under the new Lemon Grove ordinance, which I don't know how they got away with that one. But
wow.
Yeah, 120 plus relocation. I mean, it's really bad. But the answer for 9 out of 10 people is going to be 60 days. And then depending on where the property is, because we mentioned those local jurisdictions have their own local rules and they vary. Some require relocation assistance at a certain level. Some require you look at like the not the CPI, but what they publish for rent in that area and average a month. Like it's done differently depending on which one you're in. And then if it's a no fault reason, you're going to have to offer the relocation assistance. Also, if it's like for substantial remodel, which this one, always kind of irks me, because if you ever see politicians talking about these issues, they always, they're kicking people out to, so they can put in new kitchen cabinets or something and charge more. And like it's this, pandemic, so to speak, of evictions. It's not happening. It's not out there. Landlords don't really use that. One, because they've made it so hard to use. Like in the city, for example, you got to post your permit application within 3 days of applying for the permit, then post your notice with a copy of the permit attached to it, and explain in your notice like why the tenant can't live at the property while these repairs are going on for a period of 30 days. You have to offer it to them to re-rent, right? So if, hey, I don't follow through with the remod or whatever, but they leave pending this time, like they can come back and rent it. So it can be very technical and difficult. And a lot of tenant attorneys, right, the good ones, most cases aren't won on the merits. I mean, some are. Some genuinely are and deserve to be from the tenant side. But really, most of the time when you find a tenant wins, it's because a landlord didn't dot an I or cross a T on some issue on a notice or some local rule they weren't aware of. And that forces you to, knock the case out and start over. And hopefully there's no attorney's fees provision in it.
That's why we have clients to contact you and not do it themselves.
Right. And that notice is so technical and varies by all the jurisdictions. And, I get clients that I'm like, okay, well, if you're going to get the tenants out, then we need to give them a formal notice. I already gave it to them. And I'm like,
yes.
In what manner?
Yeah.
I see that all the time, the littlest stuff, right? So I just had one, forgot to put the phone number, right? So on a 3-day rent notice, you got to put where the tenant pays, obviously how much they're behind, the day, times they can come pay at the address. You got to list the phone number too. It's in the code. Guy did it himself. He forgot to list the phone number, and a smart tenant attorney on the other side, they'll churn fees. They'll ride that one knowing they've got the ace in the hole, right?
Yeah.
And you're plumbing along, not realizing, there's a fatal defect in the case. So yeah, I'm very reluctant to file on client prepared notices, even ones that are done right. Because even too, they often will like post them or whatever themselves. Registered process server is very important. There's a presumption at trial that a process server's return is accurate. I don't have to call them as a witness, right? Can just get that proof of service in through business records, and the court accepts it. But a client does it himself, and then it's in question. So even if the notice isn't technically defective, there's a process server issue where I think you lose a little bit of leverage at trial. So, but yeah, people, I get it. You're not getting rent. It's your house. You want to do it yourself, right? There's that mentality out there. But usually those are the folks that I often find need property managers the most, and they're the least reluctant to hire them or admit, that they need an attorney early on.
Then they have the biggest problem.
Yeah, exactly. I've also seen that. I had one case where they had all these apartment complexes in LA, and mom and dad had been managing them, and everything was on a written ledger. Most of the people were paying cash, and the family had like numerous children, and you can imagine what kind of shenanigans were going on there with cash paying tenants, and sometimes not paying tenants, sometimes partial paying tenants. Like one of them we took over, they're like, well, they paid this much on the 5th and this much on the 15th and this much. I'm like, oh my gosh. So yeah. And they're like, but it's been working great. I'm like, it has.
Right.
So yeah, you see all kinds of interesting things, but it's so true. The people that need it the most are the ones that are always the most reluctant. What about like when they have a property manager and the property manager does the notice? Because I've heard that before too. Like, and I think some property managers maybe are, skilled enough that they can do it properly, but I'm always kind of, hesitant to accept that as well.
Absolutely. Some of the biggest mistakes I've ever seen were from property managers who just made situations worse.
Yeah.
Dealing with one earlier today without elaborating further on that. But, and I've actually successfully prosecuted cases against property managers. One example, a client between lost rent and damages to the property was out like 60 grand at the end of it, something like that, maybe more. I forget exactly where we settled, but the tenant had 6 public evictions. How do you let this person into the house? I mean, that's the first thing you do is check for priors. So, hiring a property manager in and of itself isn't really enough. If it's just someone winging it, they're probably going to do more harm than good. But there are some really, really good ones out there. There are. I have some property managers I work with. We joke like every time we serve a notice, the people leave and we don't file lawsuits. Like we're batting 1,000 on notices. How is that? And my opinion is good management. The management's been involved. They're there. There's a relationship with the tenant, so when they get that legal notice, it's more personal, I suppose, or the tenant takes it more seriously versus, absentee management. Another big thing I see managers mess up, even good managers will make mistakes on this sometimes, is they don't claim exemptions, right? So we talked about the local rules, and then there's the state law, just cause protections, which are like kind of your baseline. Well, a lot of properties are exempt from those rules. The thing is, the exemption's not self-executing. You have to claim it in the lease. And I can't tell you how many times I get cases where we go, yeah, this is a single family residence. It's not corporate owned. There's no duplex. Like you hit every box to be exempt. but you didn't put it in the lease. So unfortunately, you're subject to these strict rules, and you got to give the tenant a check for 3 months rent, which, that could be 10 grand.
So that's interesting. So it has to be in the lease in order for that exemption to be applicable. It's
Yes.
not automatic.
Wow. That's why I send people to you to do leases.
Yeah, that's interesting. I hadn't heard that before.
And I'll tell you another one too. So for the state law exemption, right, there's a car form for it. But the way the California Association of Realtors form looks, it's very confusing the way they have boxes inside of boxes. I can't tell you how many times I've seen it. They go, oh, wait, no, don't worry, I got the exemption. And then they don't check the box on the car form.
Those forms are confusing.
It's a very, very common mistake I've seen, or a lot of managers don't even know that they're subject to these local protections. It's not like there's this big press release and everybody knows, hey, if you've got a property in Lemon Grove, like now you've got these new rules and your lease has to have this language in it. So folks will sign leases with state law exemptions that don't apply, or they just don't even know anything about exemption. And again, if the relationship goes south and you're going to have to terminate it and you're trying to do a no fault just cause, now I've got to write that tenant a check for 2 or 3 months of rent, or waive that rent. And how expensive is rent these days? I mean, so that could not check in a box, could be a $10,000-$12,000, whoopsie.
Yeah.
And then plus you're subject to all these rules that just make going through court harder. You have more you have to prove.
So what if you have a lease, but then these new ordinances or local rules come into play? Are you allowed to modify your lease accordingly, or you're just stuck with the old terms until you can renew your lease or get a new tenant?
Sure, great question. So the way the city of San Diego did it was they gave about 8 months to serve the tenant a notice of the exemption. Then if the lease renewed after that, so like your month to month, right? Which when the tenant pays you rent each month, the lease is considered renewed, right? So after that like grace period, it has to be in the lease itself. So usually that's how they'll do it. They'll give you a window of time to just serve a notice for people who've already been your tenant. Anything new, of course, that wouldn't apply. It's got to be in the lease. And then if you miss that window, you could try to backdoor an exemption in with like an 827 notice. I've seen it. I've litigated it, but it's very discretionary what a judge is going to do with that at the end of the day. So it's just best to do it correctly as, the municipal code lays out.
Seems like so many potential pitfalls and so technical that, going it alone is very risky, it seems.
That's where like a good manager is really, really important, because presumably they're up on the legal education, know that they have this obligation to do it and then get it served. And plenty of them do. Plenty of them out there do.
What would your advice be to a trustee who maybe has like an ongoing trust? Like this is going to go for the beneficiaries, till they're 50 or 60 or till they die. And the beneficiary says, well, we own this real estate and, I want you to rent it out. Because I have those situations where I'm representing the trustee and I'm always hesitant. And I think the trustee is too, to voluntarily put themselves in a situation where they're now a landlord.
That's an interesting question, and I understand it. I would say that scenario especially is important to have great management. If it's a pre-existing tenant, that makes it harder. If it's somebody new, you at least have the opportunity to vet that person. Because a lot of the people who are trouble, not all, they're repeat, because eviction cases are masked. So there's really no way to know if somebody's been evicted unless it's public. That's a whole nother topic. Most cases that are supposed to go public very often don't. You don't really know. Yeah. So
wait, what does that mean? Like it's not in the court record?
sure. So eviction cases, anything limited civil under $35,000 is masked, meaning it's not publicly available. And the only way you can access the case information, you have to have both party names, the case number, and the property address. And it sounds simple. Believe me, I've pulled my hair out a few times. You're on the system with the names, address, and somebody entered, AVE instead of Avenue, or, apartment instead of, and you can't figure it out, and you can't access like, I'm the lawyer in the case. I can't get the
Oh my gosh.
But yeah, so eviction cases are masked. And then if a tenant loses by default or after a trial, they're supposed to lose that protection. Sometimes they do, and the cases come unmasked. Sometimes they don't. I couldn't tell you why. But that it makes it hard to vet people.
Yeah.
Because that's going to be the number one thing you're looking at are priors. But if you see one, you kind of assume more. And like I said, a lot of people are professional tenants, right? So to speak. And I represent tenants too, on the commercial side, most occasionally a residential, mostly commercial. So I'm not trying to dump too hard on that side of the aisle, but if for your question about the trustee, vetting somebody thoroughly, credit checks, all that, and having good management in place is the best way that trustee is going to be able to minimize their liability or risk exposure to some sort of lawsuit for negligent management, or like they're a trustee. Yeah. They don't want to be landlords and dealing with this stuff.
Right.
So
right. Well, and that's always my concern. I mean, there was a situation you helped us with where we, had to pay quite a bit of money to this tenant to get him to leave. And, you end up in a situation like that where you've got high litigation costs because something does go wrong with the tenant. You've got high litigation costs on top of it. You're paying them to get out of your property. I can just see like that beneficiary that wanted you to rent it being like, well, what happened? But it's like, that's kind of the risk. I think anytime you lease something out, and, like you're saying, if it's hard to vet the tenants, you just, it's hard to know who anybody is till you get them in, and then you just find out.
And those, you mentioned cash for keys, right? Like those municipal codes actually set minimums. Like for example, in the city of San Diego, if you even want, they call it a buyout agreement, which I laugh at. It's really, the buyout's the other way, but it's a whole other issue.
Right.
In order to have the cash for keys conversation, they have to sign a waiver disclosure about what their rights are. This is prescribed to you by the city of San Diego. So I can't even call my tenant to say, hey, I'm going to be putting the place on the market. We're going to serve you notice. I don't want to go legal. Your rent's $2,500. We're thinking, if you go, we'll give you a check for $5,000 plus your deposit back. You can't even say that, right?
Really?
Absolutely. Until you have the tenant sign that disclosure, and then you can have the conversation. And your cash for keys deal has to be more than the minimum, right? So elderly or disabled would get 3 months rent, and everyone else is 2. So that's kind of like your minimum opening offer to folks.
Wow.
As set by the city council.
Yeah, I remember that came up in that case we had because you said we have to offer them a minimum of 2, and it's like I didn't even know that was a thing. So yeah, but you have to weigh the pros and cons, because those those fees to go to trial on these things can really add up. I know I've had some in the past that because there's the right to discovery and all that. So I mean, it's expedited though, right?
Yes and no. Rocket docket, right? It is expedited, but like we were saying before, if for some reason there's a delay in the sheriff executing the lockout or obtaining a signature on a judgment after a trial. Again, not right now, we're doing good, but it wasn't that long ago that things.
Yeah, no, I remember having a delay on a lockout. It was, a good month after we got somebody locked out that we.
A month is good. There was a time I had a post foreclosure. I want to say it was 2024, not 2025. 4 months. 4. Nothing happened. There was no bankruptcy. We didn't mess anything up. Just delay in process. We're backlogged, so that's a big part of it is just.
Well, and the process for that too is basically just the landlord just has to wait for the sheriff to call and say, we're scheduling it, right? There's no like seeing where you are in line or knowing when it's going to come. You just wait, right?
Right. So the date that the sheriff posts is the tentative date. They usually come a week or 2 weeks. I've had months after the posted date in some extreme cases.
Wow.
Because it's for officer safety, and I get it. They want people to self-evict. They don't want violence. And yes, you're right. Like you list your client or the manager or whoever they designate as the agent, and you tell people just have your phone ready. Don't miss any calls because they're going to get a call from a block number that says you've got a lockout in a couple of days. And if you miss it, that could cost you, a few weeks.
And this is after you already won the case.
Yes. So
so crazy.
Cases can take, even defaults, they can take a long time. They really can. And also too, we haven't talked about the money, right? So everything's about possession. So let's say you get a case on default. I have multiple money judgments on default case. You submit the packet, right? You can't submit it before the lockout because you don't know how many days of rent they're going to owe until they're locked out. So you submit it. It can take a year to get the packet back, and very frequently they'll kick it. It'll be some technical thing that isn't even a rule that they'll say, oh, okay, well, this is going to be rejected. Like it took you a year to tell me that, so.
And the packet is the order for the tenant to pay. What does that mean? The packet.
Yes. So like.
And you have to go collect it from a disgruntled tenant who has left?
So usually on a default case, what we'll do is a clerk's judgment by default for possession only, because that moves the fastest. That's what everybody does. It's not giving anything away. Once you get possession back, now I can look at this thing and go, okay, now I know how many dollars in, the underlying rent notice are owed, plus how many days of holdover, plus my final costs, maybe attorney's fees if there's a clause to that effect, right? So then the next step is to submit your application for entry of default money judgment, which is separate from that initial possession judgment. And those packets, right? Your client, they're all forms, but your application, the client declaration, the exhibits backing it up, those can take a year to process.
Wow.
And like I said, and many times they will be thrown back at you for stuff, and you go, oh, it took a year, and it's, oh, those weren't or something that's really not having to do with anything.
But then you have to collect on it, which seems like, what's the success rate on that? When you have a tenant, you can't slap a lien on their home,
Very low.
That seems like now you're at the extra aggravation stage of, okay, we spent a year plus doing this. I got my judgment and now I can't even collect on it.
Absolutely. Right. If they had the money, you wouldn't be evicting them in the first place. Right. Some firms have collections departments. I've had some success on collections with tenants who we knew had assets. So it's not, necessarily a dead end street. Usually where a lot of times you'll get the judgment, right? You wait the year, the default's in, so there's a money judgment. And then like 3 years down the line, somebody calls you and I was applying for an apartment and this landlord says I have a money judgment and you're the lawyer whose name's on it, so sometimes those kinds of things will happen, and then that motivates people to pay. But yeah, I always say, look, get the passenger off the train, right? Like, get your house back so you can get back to making money again. With your investment property, the collecting from the tenant, I mean, it's like not even icing on the cake. So a lot of times in a lot of stipulated judgments and things, you'll see rent forgiven. Not always, but I can't tell you how many I've had where, okay, we'll give you a 12 or a 24-month payment plan. Now that tenant's paying rent somewhere else, they're struggling, maybe they write you 1 or 2 checks before they default, like every time, they don't have it. So it's kind of like people focus on it, the clients sometimes, and I get it. It's not right and it's not fair, but ultimately at the end of the day, it's getting you possession back as fast as we legally can. If there's some money in it at the end, like amazing. But for most people, there won't be. And two, that a lot of times too, and then they'll get the place back and it's trashed, right? Like that's very, very common, or the tenant used it real hard or that kind of thing. So that's just why using a good property manager and vetting people is so important, right? What is the ounce of prevention is better than a pound of treatment. Having a knowledgeable eviction lawyer if it gets to that stage. So much can go wrong if you're just winging it, or I know some guy who does these things and they're going to take care of it. The other we haven't talked about too, there are so many lawsuits now. I mean, I practically have more civil litigation cases than I do landlord-tenant because the tenants are suing the landlords, right? Somebody messed up an eviction or did something they weren't supposed to do, not maliciously, just, and now the tenants brought a civil suit for habitability, or there's mold or whatever the garden variety claims are. And now you're an IC department litigating for years, and we all know how expensive that is. So
it's slow. It's so slow.
It's slow. A lot of it's covered by insurance, but a lot of it isn't.
Yeah.
So it's just if you're going to be in that business, which I think is a great thing, you just have to be smart and really do your homework on the front end. I wouldn't, folks, penny wise, pound foolish. I'll just do it. It's just too risky, I think. It's just my personal opinion. I haven't done this for a long time.
Just sounds like it, Lauren.
Yeah, no, absolutely. And that's what I tell my clients. And sometimes people kind of mention it in passing, like my estate planning clients, like, oh, well, I'm just going to do this and this for my tenant. And I'm like, I think you better have talk to somebody about that. And so, and sometimes, then I hear back later, that it did not go well and they end up in court. And so it's a whole big, like you said, penny foolish, pound wise, or whatever it is. Yeah. Thanks for joining us today and giving us all this knowledge around landlord-tenant issues. I feel like the more we know, the better we can inform our clients of when they should call you, basically, because a lot of people end up in these situations and sometimes they've never been a landlord before, like in our situation where they inherit this property and never dealt with anything like this in their life, or any lawyers or anything like that, which is often the case even when they come to see us. They've never been in these situations. So it's important to have people that are knowledgeable, that can lead you through them. So, and we, always appreciate you helping us with helping our clients with their situations.
Sure. It's my pleasure. Like none of it's intuitive, right? Like, oh, because I'm in this zip code, I got to follow different rules and next door and what the tenant can sue me. That's my property. Like, I'm letting you live there and this is what you pay. You would think that's how it is, but it's not. And
it's not. And like you said, you know, people they don't advertise when these laws come out. So people just don't even know. So,
sure.
Yeah.
Sure.
Well, thanks for joining us. For those of you watching, you can find Lawrence at saferlaw.com, and maybe you'll be our first third-time guest at some point in time.
Well, anytime. It's always a pleasure.
Thanks, Lawrence.
All right. Thank you. Take care.
You've been tuning in to Trust GBS with your hosts, Lori Bolander and Lauren Gallagher. You can find this show on all the major platforms, including YouTube, LinkedIn, Facebook, Apple Podcasts, Spotify, and on our website, lawgbs.com. Thank you for your positive feedback, comments, questions, and sharing this show with others.